Hey, what's up, everybody? This is Isaac from Guns for Everyone. This is the open carry Colorado long version. So when I say long, don't complain about how long this video is because I'm going to go into a fair amount of detail. But before I do, we got to say a quick prayer to Santo Edgar. Santo Edgar, please help this video to not suck. All right. Oh, it went out. That's a bad sign. That is a very bad sign. Okay, there we go. All right, Santo Edgar's not on my side. All right, since it's a long video, let's get a little energy boost here. So the point of this video is to improve your understanding of the Colorado open carry laws as they exist in 2025. This is obviously not legal advice. I'm not an attorney. I'm barely qualified to be doing this. But I'm trying to give a comprehensive view of open carry for the state of Colorado. So let's start with the definition of open carry. The best reference you're going to find in the law for definition of open carry is the word display. It's not defined, but it's spoken of in those terms. The open display of a firearm is specifically, if you look at CRS 18.9.106, the disorderly conduct, 1F, not being a peace officer displays a real or simulated firearm. So the word display is mentioned there. As opposed to conceal, which doesn't really have a definition in Colorado law. There are two court cases that are the most relevant to this. One specifically has to do with the concealment of the weapon and what is defined as whether or not something was concealed. And that is a court case from 2009. The people ex real or. And I don't know what ex real or means because it's usually people versus so-and-so. But this involved a minor, so I think that's why it's labeled that. I will be putting a link to this case in the description. But essentially, with people ex real or, we have if the firearm is not readily discernible through ordinary observation. And some basic details of this case. There was a minor who had a gun sticking out of his pocket when he was being pursued by the police, and he was arrested for all kinds of things, including unlawful concealment of a weapon. And the case went to the state Supreme Court, and the state Supreme Court stated that concealed needs to be not readily discernible under ordinary observation. The other case involves the People versus Sanders. And this case has to do with intent. This is 1962. This has to do with intent. There has to be intent as part of the concealment of the gun. That case is a little bit more complicated, but it affirmed that intent needs to be part of the crime. If there is no intent, there is no crime. The jury is the one that determines intent. There was another court case, which I can't remember off the top of my head, talking about the jury needs to be the one that determines that intent. It can't be done from the bench. Okay, so what we have here, definition of open carry is basically not concealed. If it's not concealed, it's open. And the advice I give to people when it comes to this is if you're going to open carry a firearm, open carry the firearm. Sorry for that slight pause. And if you're going to conceal a firearm, conceal it. Don't try to ride some kind of line. Don't try to stuff the gun into your pants halfway and say, "Does this count?" Like, you're asking for trouble. you're asking for arguments with a police officer that you probably don't want to have. So if you're going to open carry, meaning the holster, the entire holster is outside of the pants. All right, so grab my notes again. So disorderly conduct is when a person displays a firearm, quote, in a manner calculated to alarm and does cause alarm. So it's not just the presence of the firearm, it's carrying the firearm in a manner that's calculated to alarm. That could be interpreted a lot of ways, but traditionally in Colorado that has not been interpreted as just having the gun on you. There have been a couple of cases that I know of where somebody was open carrying a rifle and the police were called and the person was not contacted by the police because the rifle was not being displayed in a manner to cause alarm, even though eventually the person did go on to use the gun in a crime. So what I'm trying to say is, generally speaking, that calculated to alarm and does alarm is interpreted very liberally, meaning just having the gun is not typically construed as you trying to cause alarm. Okay, we have a couple of statutes here that relate to the carrying of a concealed firearm or the unlawful possession of a firearm. So we're going to go to, so disorderly conduct is 189106. That's disorderly conduct. Disorderly conduct. I'll try to put these statutes in the description as well so you can go look them up. 1812-105, 105, not 150, 105, relates to the unlawful carrying concealed and unlawful possession. It is in part 2 here. It is not an offense pursuant to this section if the defendant was in his or her own dwelling, place of business, or on property owned or under her control. So it is not unlawful to possess a weapon on your property, open or concealed. A person in a private automobile or other means of conveyance who carries a weapon for lawful protection of such person. That is not open or concealed. That is just the possession of a weapon. And it is not an offense if you hold a valid permit to carry a concealed handgun or temporary emergency permit if you're carrying that weapon concealed. So that means that those three circumstances, your property, a place of business under your immediate control, or your vehicle, open or concealed, is essentially the same thing. It is just the possession of a weapon. There is no distinction between open or concealed. So that is carrying gun or possessing. All right, so the next statute that's relevant here is 1812-105.3. So 105.3, you cannot carry in the legislative assembly. So you can't carry in the Capitol building unless you're specifically permitted to do so, which we're talking security guards, police, etc. This includes the entire Capitol building and the adjacent parking lots. Part B of this, so that's A, and then Part B is local government, and the same thing. Anywhere where governance is happening, so you could have your city council meetings, you could have your county commission, you could have your town council or whatever. And again, that does include the adjacent parking lots. And then Part C is courthouse. Can't carry in a courthouse. Okay. But this does not apply to a person who has a valid permit to carry in the parking lot. So there's no open carry on any of this property. There is concealed carry allowed in the parking lot of these places. But a local government may enact an ordinance or regulation or other law that permits it. So by state law default, it's not allowed, but a local government can permit it. I believe, don't take my word for this, but I believe it's true that in Castle Rock, you can carry in the courthouse or in the government buildings, you can open carry because the city of Castle Rock has permitted it. That might have changed. That might be old information, but that's an example. So, and then nothing, and this is part 5 of 105. Nothing in this section prohibits a person from securely storing a firearm in a vehicle as required by state law that is at a location described in this section. So you can still have it locked in your car when you're out of your car when you're on these properties. Okay. 1812 105.5. 105.5 is educational facilities. And this includes licensed child care centers, public or private elementary, middle, junior high, or vocational school, or any public or private college, university, or seminary. So you cannot knowingly carry a firearm either openly or concealed on the real estate and improvements erected thereon of those properties. There's some exceptions in there. The exceptions are not really important to this discussion. They're more for, employees and security guards, etc. And if you violate this right here, it's a class 1 misdemeanor. You can have the weapon in the vehicle for that, but it must stay in the car. It must be locked up under all the safe storage laws. And the person, the other exception is if you own property within that is within the area, then you can carry on your property. That is not preempted by this. You can have it in your car you can have it under your possession in your car while you're on that property as well. Let's see. Yeah, so this doesn't preempt any of the concealed carry laws around that stuff. So it's a little confusing. I don't want to get too much into the weeds with that stuff. It's basically if you have a permit, you can have the gun in your vehicle while you're in the parking lots. When you get out, you have to lock it up under those requirements. Okay. In your vehicle, let me go back up here. Local jurisdictions cannot preempt you carrying in your vehicle. Remember, we said there's no such thing as open or concealed when you're actually in your car. Local jurisdictions can't preempt that because the state has determined that is a matter of statewide concern, and local jurisdictions, including the city and county of Denver, do not have preemption on that. And that is under 105.5 as well. That is, point 6, and that is 2A, part 2A. So it states is a matter of statewide concern, and that language triggers that the state has preemption over the local laws. Okay. There is another law here, Title 1, Article 13 and 724, and no guns at polling places. You can't have the gun within 100 feet of a polling location where ballots are accepted during the election. So when ballots are being accepted, so that includes early voting and all that stuff. So it says unlawful for any person to carry a firearm within any polling location or within 100 feet of a drop box or any building in which a polling location is located. The exception to that would be if you were on your property within that 100 feet. So if you had a business that was within 100 feet, you could have the gun at the business, but not outside the business. Okay. So let's talk about who can't do any open carry. And that's 1812-108.5. If I was Edgar, I'd have all this memorized, but I don't. I have it on paper. So, except as provided in this section, it is unlawful for any person who has not attained the age of 18 years knowingly to have any handgun in your possession. So that's concealed or open. So that means anybody over 18 can. This does not apply to anybody under the age of 18 who is hunting or trapping pursuant to a valid license issued to such person pursuant to the hunting statutes, Article 4, Title 33. Or traveling with a handgun in such person's possession being unloaded to or from any activity described in the subsections. And there's a few other places where minors can possess a firearm, competitions, etc., but we're talking general possession. So, or any person under the age of 18 who is on the real property under the control of such person's parent, legal guardian, or grandparent, and who has the permission of such person's parent or legal guardian to possess a handgun. So that means your 17-year-old can carry a handgun at home on the property with permission from a parent. It doesn't say under the supervision. It says has the permission of such person. Or any person under the age of 18 who is at such person's residence and with the permission of such person's parent or legal guardian possesses a handgun for the purposes of exercising the rights contained in 18-1-704 or 704.5, and that is the self-defense or the home defense statutes. So that means a person, let's say your nephew or even your child's friend, I mean, the way I'm reading this, any person under the age of 18 years who is at such person's residence with the permission of such parent or legal guardian possesses a handgun for the purpose of self-defense. All right. Again, I'm not a lawyer, so be careful with that one. And then 1812-108, part, let's see. I'm getting confused here. 1812-108-1. So this is juvenile, and this is previous offender. So typically we're talking your convicted felons. The convicted felon or any other person who is prohibited from possessing, using, or carrying a firearm as defined in 18-1-901 is not allowed to possess, carry, etc. But possess is the key word there. There's another part of this, though, that is important to understand, and there are a couple of convictions that you can have that are not felonies, but could prevent you from having the right to carry a firearm, and that, or possess a firearm, and that includes unlawful conduct involving an unserialized firearm frame or receiver, unlawful manufacture, distribute, transfer, sale, or purchase of a specified semi-automatic firearm. So there's some newer laws in Colorado that prevent you from having 80% lowers, etc., blah, blah, blah. Or if you are found to be in violation of any semi-automatic bans, which this is coming up next year, that prevents you from, that you will lose your firearm rights for a specified amount of time, and in that time you can't possess any guns. So it doesn't really have anything to do with open carry, but it's another class of people who would not be permitted to open carry because they are not allowed to possess firearms at all. So, and there's one more group of people in this prohibited person, and that is a new law, 1812-110. As a condition of your adjudication of a case, if you agree to forfeit your rights to have a gun. So that means you weren't necessarily convicted of a felony, but you, as a condition of your adjudication, have agreed to forfeit your rights to possess firearms. And I'm not going to get into that right now, just to say that there is another specified situation where it wasn't a felony, but you still don't have your firearm rights. Local jurisdictions can create their own laws prohibiting the open carry of firearms on certain public property. So I mentioned in the short version, you have a library in the city of Colorado Springs. The city has prohibited open carry in libraries and police stations and places like that, the DMV. So you have a responsibility to know the local jurisdictional laws. Denver County prohibits open carry throughout the entire county, and that's under a home rule designation. And I'm not really educated on the intricacies of home rule, other than to know that Denver does enjoy home rule and prohibits open carry anywhere in the city of county of Denver. But remember, that does not include in your vehicle, private means of conveyance, or on your property. So to summarize, you can, if you're over 18 and not a prohibited person, you can open carry anywhere in the state where it's not prohibited. These are a bunch of the prohibitions. So do your research if you're going to open carry. Now, a note on whether or not open carry is a good idea. Generally speaking, in more densely populated areas, you are more likely to run into somebody who is going to create a problem for you open carrying. And a problem for you means anything. It doesn't necessarily mean that you're breaking the law, but it could mean unwanted police contact. So you're open carrying at King Soopers and nobody has said anything to you, but somebody called the cops, and now you're about to have a conversation with the police when all you wanted to do was your grocery shopping. So generally, I advise against open carry for that reason. I also advise against open carry because you're more likely to run into somebody who might look at your gun as an opportunity to take it from you. And fighting over a gun is difficult and dangerous, and it's not something I would recommend that you open yourself up to unless it's necessary. So people that I consider more appropriate for open carry would be an 18-year-old, 19, 20-year-old who wants to protect themselves lawfully and is going to exercise their right to open carry because they cannot get a concealed carry permit until they're 21 years old. People who can't afford a concealed carry permit, or people who morally object to asking for permission from your local king to carry a gun. So I understand all those objections, and if that's your moral objections to getting a concealed carry permit, I understand the logic. I don't necessarily always agree with that logic, but don't open carry unless you need to. And your definition of need is your subjective definition of need. Otherwise, conceal it. You gain the element of surprise. You gain the peaceful existence of not having other people interfere with your life because they don't like what you're doing. Conceal. Places where it makes much more sense to open carry would be if you're hiking. If you are, hiking, and concealed carrying can get rather uncomfortable or cumbersome. If you are in a remote area, so maybe you're not hiking, but you're camping or something like that, that makes sense. Balance of risk and benefit. Open carry represents more risk in certain ways than concealed carry does. So balance that risk and benefit to yourself, your subjective understanding, take an appropriate view of balance of risk and benefit, understand the risks, and take reasonable steps to mitigate those risks. So if I left anything out or didn't answer a question that you had, please put it in the comments. I will do my best to answer. I will also put these references in the comment or in the description. And I encourage you to do your research and don't take my word for it. Go and read the law. And as always, if you want real concrete legal advice, talk to an attorney. Check us out, gunsforeveryone.com, gfenational.com, free concealed carry classes across the state of Colorado. And I appreciate you guys for watching, and I will catch you later.